Have you ever wondered how the family law system in Australia got so bad? Well, here's a few clues to how it happens and why the system continues to be so rotten. This is a discussion paper that's been put out by the Australian government, in fact by the Australian Law Reform Commission. It's a discussion paper which is part of a, quote, comprehensive, end quote, review of the family law system. So I'm going to check out exactly how comprehensive this review is, which is meant to be the first comprehensive review for decades. So let's see. I'm going to put some terms into the document and see how often they come up. So first of all, child comes up over 1,000 times, as you might expect. If we type in parent, obviously that will come up quite a bit as well, 572 times, so that's a lot. How about women? And that comes up a reasonable amount, 245. You've got things like women's chair of a council. Let's scroll through a bit. Women's legal services. There's a report, women surviving family violence, women's legal centre, women lawyer, and so forth. So 245 for women. How about we try something a bit different? Let's try disab, which is for disabled or disability. That comes up 243 times. So people with disability, people with Disability Australia, disability organisations, people with disabilities, and so on. So that's 243 people, quite a bit. How about another demographic group? Let's try Aborigine. So I'll go Aborig, and that comes up, still going, 167 times. So things like Aboriginal and Torres Strait Islander legal services. Aboriginal community controlled organisations, Aboriginal health, Aboriginal and Torres Strait Islander, so that's 167 times. While we're on the demographic groups, let's look up LGBT, and that extends to IQ as well, so some of these groups. So we've got 58 appearances. So LGBTIQ and disability organisations, LGBTI Health Alliance, LGBTIQ and disability organisations, LGBTIQ people. There's a Ministerial Advisory Council to do with that. So they're well represented, as you'd expect, I guess, these days. Okay, let's look at some male terms. So let's try father. That appears 32 times, which is not as many as the other groups, obviously. So fathers reporting that they receive a lower proportion of the asset pool, including a program for fathers, parenting services for fathers. So they appear a bit, but not a huge amount. Okay, let's try some different terms. How about shared care? I mean, obviously that's very important to many parents when they go to court, because that's what they're after. Shared care. So it appears a total of 2 times. So shared care appears twice. Let's just see the context for this. Submissions and academic commentators have criticised the complexity of the decision-making framework. These include concerns about, we scroll down, the presumption of equal shared care. So it's basically a criticism of the requirement that you look at shared care as a possible outcome. What's the other reference? Where is it? I'll just scroll down. Must be on this page somewhere. Or maybe it's the top of the page. Where is it? I can't see it. Presumption. Oh, there we go. Stakeholders suggested that a strong community perception remains that the Family Law Act provides a presumption of equal shared care. I'll keep going. From the material provided in submissions, the ALRC considers it likely that this is in part a result of the explicit link drawn between the presumption of equal shared parental responsibility and the requirement to consider equal time or substantial and significant time. Some submissions also suggested that this misinterpretation of the law may cause victims of family violence to agree to inappropriate and unsafe arrangements. So basically they're criticising the presumption of equal shared care idea, and that's basically saying that a child has two parents. So, well, that's how they feel about that. So essentially they buried the idea of shared care in the report, mentioning it only twice, and both times in a critical vein. Okay, well, they don't like shared care. What about shared parental responsibility? That's far enough. 6 times. What does this say? Furthermore, submissions indicated significant confusion about what the result of an order for equal shared parental responsibility is. So again, they're being critical about it. Okay, well, let's try something else. Obviously, they're not big on shared care at all. How about something different? Let's try, actually, I've got a selection of terms here that I know appear a bit. So let's try trauma. That appears 70 times, such as trauma, physical disability or controlling partner, family violence and trauma, issues of cost and trauma, professionals trained in working with trauma. So there's a lot of trauma apparently in family court, where a lot of people go just because they got divorced and they need to work out what happens next. Okay, trauma is a big one. What about abuse? We type that in, we get 151 times they mentioned abuse compared to shared care, which appeared only twice. So abuse and domestic abuse and harm, child abuse and neglect, domestic abuse, allegations of abuse, risk of systems abuse, physically abused, physical abuse, definitions of family violence and abuse. So 151 mentions of abuse. Let's keep going up the list. How about risk? Risk. Still count 179 times. So risk assessment, well, that's quite innocuous, but there's some other ones. National risk assessment. I'll get away from this section. What have we got? Psychological risk of harm, unacceptable risk of harm, risk of cost orders, well, that's just a general term. Risk of fragmentation of practice. Okay, well, it's probably not really relating to family risk as such. How about care? So shared care got mentioned twice. Care itself, 268 times. Caring, 5 times. So I don't really care about care. Let's try safe and safety. Another risk variable. We've got safety hubs. So safe and safety appears 337 times. So we've got safety hubs, safety and best interests of the child, child's safety and best interests, safety first, safety and best interests, child's safety and best interest, or safety. It's obviously quite a big concern. So shared care 2 times, safe or safety 337 times. But check out this result. I had a look at this earlier. So we'll go violent, which could be violence or violent. Have a look at this. 954 times the terms violent or violence come up. So we've got abuse or family violence or abuse, family violence, National Family Violence Prevention Legal Services Forum, family violence or abuse, family violence amendments, family violence. So it looks like family violence is really the one. Let's type in family violence. Still going here. 775 times family violence appears, and remember, shared care appeared twice. So they're not, obviously the Family Law Reform Commission, the Australian Law Reform Commission is massive on family violence. They love family violence. 775 appearances, whereas shared care, which is honestly what most dads, when they go into court, that's what they're really hoping and praying for, and that's the whole focus of going into court in the first place, that appears twice. So great. Well done, the Australian Law Reform Commission. Okay, let's go on and look at some other groups. How about we look at some more occupational things? How about professionals? That's 294 times. So skilled professionals in the family law system, professionals in family law, professionals involved, professionals working in the post-order parenting support service, social science professional with training and expertise in child development. So we certainly need a lot of professionals. 294 times that comes up. What about dispute resolution? I'll just type in dispute res. That appears, still going, 197 times, so that's quite an emphasis, you'd say. What about lawyer? Still going, 152 times. They talk about lawyers. What about, say, judicial officer? It's a bit smaller, but here we go. 91 times they talk about judicial officers. So lots of professionals. Judge, 56, that's not too many. Magistrate, 13. Oh no, hang on, still going. 21 times they say magistrate. All right, let's try self-represented. I'll try self-rep that way. So self-rep gets 12 times. I'll just make sure it's not because of spacing. No, 12 times. So we've got all those other groups appearing dozens or hundreds of times. Self-represented appears 12 times. So they're not big on really accommodating self-represented litigants in the family court, but as we all know, increasingly a lot of people, to save on legal costs, are going in themselves. Okay, let's look at another issue. Something that comes up in family court a lot is the idea of false claims. So particularly with false claims of domestic violence. So you've got often couples with no history of violence at all, but when they get divorced and go to court, suddenly there's issues of violence and fear and so forth. Of course that can be legitimate or it could be made up, but many thousands of people who've gone through court have said the claims were false, exaggerated or misleading. So anyway, let's type in false, 0 results. Okay, that's somewhat of a surprise. 0 results for false. So false allegations. Well, let's try allegations. Or allegation. That appears 6 times. 9 times. Just popped over. Among the 13 identified factors are allegations of abuse, where there is intractable conflict. The father denied the allegations. So allegations come up a little bit in the report. Nothing like the issue is. False is never associated with allegation. What about misleading? 0. What about lie? The simple act of lying. Do people lie in the family court? Hang on. They do, but let's put a space around either side of lie. Forget the actual word. Oh, it's 0. So people never lie in the family law system in Australia. And let's try dishonest. Maybe we missed something. Dishonest. 0. So, in the family law system in Australia, according to the Australian government, never do you have false, misleading, lie or dishonest things happen. So, well, that just shows you what this report is all about. Let's go back to the top. So here it is. This is the review of the family law system discussion paper. So just to summarise what we've found by just looking through it, father, man or men, terms like that, they appear a total of 40 times. Terms that appear more often than anything to do with being a father are LGBTI or LGBTIQ, Aboriginal or Aboriginal, disability or disabled, which appears for every one reference to a father there are 6 references to disabilities. Self-represented appears 12 times. Other groups such as professional, dispute resolution, lawyer or lawyers appear in the hundreds of times. In terms of false, misleading allegations, dishonesty, all of that, it doesn't appear at all in the report. So apparently everyone who goes to the family law, enters the family law system, is telling the 100% complete truth. Shared care appears twice. Twice in the entire report do they say shared care. And both times it's to say what a bad idea it is to have that term in the legislation. But the words violence or violent appear nearly 1,000 times. You've also got abuse appearing 151 times, trauma 70 times. So this report by the Australian government, it's not about reforming the family law system in a meaningful way. What it's really about is emphasising once again that fathers who happen to get divorced from their partners are violent, risky threats to their children and therefore shouldn't be allowed near their children. Let's have a look at the people who are responsible for the discussion paper. This is the advisory committee for the review into family law. These, I guess, aid the Australian Law Reform Commission in developing its papers and ultimately will guide the writing of the final report. You can see it's quite an extensive list. Now, I'm just looking here for some people who represent the general community. So the poor mothers and fathers and others who go through the family law system and find out exactly how bad it is on a personal level. I'm struggling to see anyone. So we've got President of the Family Law Practitioners Association of WA, Executive Director of Family Relationships Services Australia, Strategy Manager, No to Violence Men's Referral Service, Judge Amanda Chambers, the Honourable Richard Chisholm AM, former Family Court of Australia, Legal Practice Director, Women's Chair of ACT Human Rights Commission, someone from Melbourne Law School, an academic. That's great. We need more of those involved. They really help. Who else have we got? CEO and Principal Registrar of the Federal Circuit Court. We've got the Honourable Justice Mary Finn. We've got Regional Coordinator for Child Dispute Services. Managing Director of Victoria Legal Aid. Those legal aid people, you know, they always stand up for men. Not. Magistrate Anne Goldsborough. We've got Executive Director, Department for Child Protection Adelaide. Consulting person, Dr. Victoria Havane. Accredited Family Law Specialist, a lawyer. We've got another lawyer, Women's Legal Service Rep. We've got a clinical psychologist. They always do such a good job of writing those family reports where they usually recommend that the father's a danger or something. We've got Aboriginal Family Law Services. Of course, we need lots of Aboriginal representation. It's such a coloured issue. Not. We've got National Children's Commissioner. His Honourable Judge Matthew Myers. CEO of ANROS, which is a political organisation, I believe. Actually, let's look it up. ANROS. Can I look that up here without losing anything? and Rose. Our women's group. Okay. We've got the Honourable Richard O'Brien, Family Court of Australia, Managing Solicitor, Executive Director of Family, Youth and Children's Law, a legal partner, another academic from Melbourne Law School, the Honourable Justice Gary Watts, her Honourable Judge Gillian Williams. All right, so these people, they're part of the industry. Every single one of them, they're either a lawyer, a judge, a consultant, someone involved in the government lobbying side, mostly on the women's side or children's protection. So who are the people who represent the mums and dads who go through the system and cop it? And just looking at this advisory committee, what a huge committee, 2, 4, 6, 8, 10, 12, 14, 16, 20, 24, 30, well, it must be over 30 people. Not one of them can actually say, well, I went to family court and this is what happened and it sucks and it needs to be fixed. And I guess that's how you can come up with a report that's as rubbish as the one we just went through, that discussion paper. What a load of rubbish. It manages to do hundreds of pages, manages to mention the word family violence hundreds of times, and it can't look at the basic issues. When you go to court and it's about parenting matters, all you want to do is get a timetable to see your kids. That's why you go there. You don't go there to be subjected to family violence vetting and all the rest of it. And the real issue is about shared care. Kids do better with two parents. Even if the parents are separated, the kids are always, according to the stats, kids are better off with two parents. So saying that shared care is treating shared care as a dirty word while emphasising violence, that's no good for kids. And all these dopes, that they should be ashamed to have their name associated with this thing. What are they thinking? That rubbish report, and they're attached to it. Each one of these people, if they had any honour, any sense of decency, they'd stand up to the people writing the report and stop it being written the way it is, or else they'd resign. They shouldn't be on here. So to all of those people, I say, well, you're highly esteemed, but you're doing a crap job. And I'm not impressed by what you're doing, and I think you should make a stand and stop it.